Good day. My name is Sharon. In this presentation, I will critically analyze how directors' duties are discharged within the UK corporate governance framework and how stakeholder analysis influences their decision making and accountability. The analysis will consider the Companies Act 2006, leading case law, stakeholder theory, and practical governance challenges. Section 172 of the Companies Act 2006 represents a pivotal provision in UK corporate governance, codifying directors' duties to act in a way that they consider, in good faith, would promote the success of a company for the benefit of its members as a whole. Importantly, this section also requires directors to have regard to a range of stakeholder interests, including employees, suppliers, customers, the community, and the environment. However, despite its progressive language, the enforcement of Section 172 remains limited in practice. Crucially, the provision is procedurally unenforceable by stakeholders who have no direct right of action. The business judgment rule further complicates enforcement. Courts are generally reluctant to second-guess directors' decisions made in good faith and within the bounds of their discretion. In Regent Crest plc versus Cohen, the court held that the proper test is whether the director honestly believed that they were promoting the company's success, not whether the decision was objectively correct. This creates a high threshold for challenging board decisions, even if they appear to neglect stakeholder interests. Similarly, in Item Software versus Fasaheen, the Court of Appeal held that directors owe a duty of loyalty and must disclose their own misconduct, even when it is against their personal interest. Although the case predated the Companies Act 2006, it has been widely cited as supporting the principles now reflected in Section 172 and Section 175, particularly concerning acting in good faith and avoiding conflicts of interest. In addition to Section 172, directors in the UK are bound by several other statutory duties under the Companies Act 2006, each of which reinforces principles of accountability and good governance. Section 171 requires directors to act within the scope of their powers and to comply with the company's constitution. This ensures that directors operate within legal and structural boundaries established by the company's Article of Association. Section 173 mandates that directors exercise independent judgment. They must not allow themselves to be unduly influenced by others, thereby safeguarding autonomous decision making in the best interest of the company. Section 174 sets the standard for care, skill, and diligence, combining both objective and subjective elements. This was illustrated in Re Dejan of London, where the director was held liable for failing to read an insurance form, demonstrating that the expectation that directors meet both professional and personal standards of competence. Section 175 obliges directors to avoid situations in which their personal interests could conflict with those of the company. Section 176 prohibits directors from accepting benefits from third parties, such as bribes, which help to preserve ethical standards and corporate integrity. And lastly, Section 177, which requires directors to declare any interests that they have in a proposed transaction with the company. This promotes transparency and accountability, as exemplified in Neptune Ltd versus Fitzgerald, where failure to disclose a conflict impaired trust in governance. Some cases that have been linked to directors' duties are Rees Smith and Fawcett. This case established that directors must act only within the powers conferred upon them by the company's constitution and for proper purposes. It also affirmed that directors' discretion must be exercised in good faith and in what they believe to be in the company's best interest. Howard Smith and Ample Petroleum. The court held that directors had acted for an improper purpose by issuing shares to dilute a majority shareholder's control rather than for the benefit of the company. This case is central to understanding the limits of power under Section 171B of the Companies Act 2006. Regent Crest and Cohen. This case clarified that under Section 172, directors are judged by a subjective standard. The question is whether they honestly believed they were acting in the best interest of the company, even if the outcome was ultimately poor. The court does not substitute its own judgment for that of the director. Jan of London. A director was found personally liable for negligently signing an insurance proposal without reading it, which led to a voided claim. The case confirmed that directors must meet the standard of care, skill, and diligence as expected of someone in their role. Item Software and Fasihi. The director failed to disclose his own misconduct and competing interest while still employed. The court held that even loyalty to the company requires full disclosure of breaches of conflict. This case underpins the strict duty to avoid conflicts of interest. And lastly, Neptune and Fitzgerald. In this case, a director failed to disclose his personal interest in a transaction, breaching the duty to declare such interest under Section 177 of the Companies Act. It highlights the importance of transparency in decision making. Corporate governance in the UK refers to a system of rules, practices, and processes by which companies are directed and controlled. It defines the relationship between a company's board shareholders and their other stakeholders, and sets standards for ethical decision making, accountability, and performance. The UK approach is principle based rather than rules based, meaning companies are expected to comply or explain. Comply or explain is a key feature of the UK corporate governance system. It means that companies are expected to comply with the principles and provisions of the UK Corporate Governance Code. But if they choose not to, they must publicly explain why. This flexible principle-based approach allows companies to tailor governance practices to their specific context while maintaining transparency and accountability to shareholders. It encourages thoughtful governance rather than a one-size-fits-all rulebook and relies on marketing discipline. Shareholders and stakeholders evaluate whether the company explanation is reasonable. Freeman's stakeholder theory presents a significant shift from the traditional shareholder-centric views of the firm. Instead of focusing solely on maximizing shareholder value, Freeman argues that corporations should consider the interest of all stakeholders, any individual or group that can affect or is affected by the organization's operations. This includes not only shareholders but also employees, customers, suppliers, communities, and even the environment. At the heart of this theory lies the importance of identifying, understanding, and engaging with stakeholder interests. This is where stakeholder analysis becomes essential. By systematically mapping out stakeholders according to their power, influence, and interest, the companies can prioritize engagement and tailor their strategies to address specific concerns. To further delve into what Freeman created, stakeholder theory that was developed by him challenges the shareholder-centric model. It argues that directors should consider the needs of all stakeholders, not just shareholders. This theory is crucial in preventing and resolving conflict. By understanding the concerns of each group, from employees to suppliers and communities and customers, companies can avoid backlash and reputational damage. One effective tool for managing these dynamics is the Mendelow's matrix, which maps stakeholders based on their power and level of interest. Box A, low power and low interest, requires minimal effort. Box B, high interest but low power, should be kept informed. Box C, high power but low interest, must be kept satisfied. And Box D, high power and high interest are key players. Directors must actively engage and consult with them. Using this matrix helps prioritize engagement strategies, reduce resistance, and enhance governance. This directly supports directors' duties under Section 172 of the Companies Act, 2006, where they are expected to consider employee supplies and environmental impact. The matrix helps directors focus their attention on key shareholders, ensuring that their duties of care, loyalty, and transparency are directed where they matter most. By mapping out influence and interest, directors can access the potential risk or support associated with strategic decisions, ensuring ethical and stakeholder-conscious governance. Some companies that follow the stakeholder analysis are Unilever, and they do this as they integrate sustainability into their core strategy. And Unilever annual report include detailed sections, 172 statements outlining how decisions impact various stakeholders. Marks and Spencers also do this because they operate under Plan A sustainability framework to balance profit and social and environmental responsibilities. Marks and Spencers uses Section 172 statements to explain how stakeholder feedback shapes business decisions. Two cases which show the harm of transparency and governance is the Carillion case of 2018 and the Tesco case of 2014. Carillion's bankruptcy in 2018 marked a turning point in UK corporate governance. The directors focused on short-term profits, exorbitant dividends, and unsustainable growth, ignoring significant financial risks. More than 3,000 jobs were cut and the company was left with a significant pension gap. Suppliers and subcontractors went unpaid. This case highlighted how obvious failings in both accountability and regulatory oversight, and highlighted the inability of current regulations to protect non-shareholders, stakeholders. Carillion's demise was caused by inadequate financial management, excessive risk-taking, and ineffective governance. The corporate has harmed hundreds of employees and subcontractors and highlights the dangers of ignoring stakeholder concerns. In 2014, Tesco overstated its profits by about 250 million, leading to a regulatory investigation and a decline in shareholder trust. This case highlights the importance of transparency and accountability in corporate governance. Accountability in UK corporate governance is maintained through a combination of institutional mechanisms and regulatory oversight. One of the key avenues for enforcing director accountability is the annual general meeting known as AGM, where shareholders are given an opportunity to scrutinize company performance, vote on key resolutions, and question directors directly. AGMs act as a forum for transparency and shareholder engagement, reinforcing directors' responsibility to justify their actions to the owners of the company. In addition to AGMs, internal board scrutiny and company structures play a crucial role. Audit, remuneration, and nomination committees, typically composed of non-executive directors, are tasked with overseeing financial integrity, executive pay, and board appointments, respectively. Externally, the Financial Reporting Council provides further oversight. It monitors corporate reporting and enforces standards related to audit and governance. The FRC is also responsible for maintaining the UK Corporate Governance Code, which is the cornerstone of UK corporate accountability. The UK Corporate Governance Code operates on a comply or explain basis. This flexible approach does not mandate rigid compliance, but requires companies to either adhere to the code's principles or provide a clear and reasoned explanation for any deviation. Despite the existence of a comprehensive corporate governance framework in the UK, directors continue to face numerous challenges in effectively discharging their statutory and fiduciary duties. A primary challenge lies in navigating the inherent tension between short-term financial performance and long-term sustainability. Directors are frequently subjected to pressures from shareholders demanding immediate returns, which can incentivize short-termism at the expense of strategic, sustainable growth. This dynamic necessitates a careful equilibrium whereby directors must reconcile immediate performance expectations with their broader obligations to ensure the company's enduring success. Additionally, the increasing complexity of the global business environment compounds these challenges. Rapid technological developments, intensifying global competition, and shifting regulatory frameworks require directors to exercise agility and remain continuously informed. Within this landscape, directors must also manage diverse stakeholder interests, often characterized by conflicting priorities, which complicate strategic decisions making and ethical accountability. The emergence of activist shareholders has introduced further complexities. These investors frequently seek to influence board-level decisions, including changes to strategy, governance practices, or capital structures. While shareholder activism can foster improved accountability, it may also conflict with the long-term vision of the board, requiring directors to navigate these tensions with diplomacy and prudence. Another significant challenge arises with the practice of greenwashing, where companies portray their environmental or social impact more positively than reality. This practice often involves vague or misleading disclosures, which can undermine the transparency and accountability principles fundamental to good corporate governance. From a director's duty perspective, the obligation to act with due care, diligence, and in good faith requires truthful and clear communication. When directors allow vague disclosures or greenwashing to persist, they risk breaching these duties by misleading stakeholders or prioritizing reputational benefits over genuine corporate responsibility. Stakeholder analysis plays a crucial role here. Directors must identify and consider the interest of all relevant stakeholders, not just shareholders. This analysis influences decision-making by pushing directors to ensure disclosures are accurate, comprehensive, and reflective of true corporal impact. Volkswagen Dieselgate scandal is a prime example of directors failing their duties through misleading disclosures. The company falsely claimed its diesel cars were environmentally friendly, passing emission standards while emitting pollutants well above the legal limits. Directors' duties impacts are that they breach their duty to care and honestly be honest by allowing misleading information to be communicated to regulators and stakeholders. The lack of effective oversight and accountability within the board allowed unethical practices to continue unchecked, and shareholders suffered financial issues and losses. Regulators imposed heavy fines, and public trust was severely damaged. One way directors have sought to demonstrate accountability is through corporate social responsibility initiatives. CSR serves not only as a tool for ethical engagement, but also as a mechanism to align corporate conduct with stakeholder values. Directors play a pivotal role in designing and overseeing these programs, ensuring that they reflect the company's ethical commitments. Although the Companies Act outlines extensive duties, practical enforcement for stakeholders is weak. Recommendations include stakeholder enforcement rights, ESG auditing, and adopting international models such as the Germany two-tier board structure. Section 172 of the Companies Act 2006 is fundamentally limited in its effectiveness due to a lack of enforceability and over-reliance on directors' subjective judgment. The section requires directors to have regard to a range of stakeholder interests such as employees, suppliers, communities, and their environment, while promoting the success of a company for the benefit of its members as a whole. However, the phrasing offers directors board discretion, and in practice, enforcement is almost exclusively at the hands of the shareholders, who may not share the same priorities as other stakeholders. As such, courts are reluctant to question directors' business decisions if they are made in good faith, as seen in Regent Crest and Cohen. Scholars such as Kay have criticized this framework as inefficiently robust, suggesting that it creates a symbolic rather than substantive accountability. Therefore, in response, several reforms proposals have been put forward. These include establishing a mandatory stakeholder advisory panel to institutionalize non-shareholder voices in governance, enhanced training for directors to better equip them with shareholder management competencies, and a broader move toward pluralistic governance models where stakeholders are granted formal participatory rights. These proposals reflect a growing consensus that meaningful reform is needed to ensure that stakeholder interests are not only considered but are also acted upon within corporate governance. Directors' duties in the UK are increasingly evolving beyond narrow shareholder primacy, embracing a more inclusive approach through the enlightened shareholder value model under Section 172 of the Companies Act 2006. This shift encourages directors to consider the long-term impact of their decisions on a broader set of stakeholders, including employees, communities, and so forth. However, in practice, this duty often lacks enforceability and transparency, leading to a box-ticking disclosures rather than meaningful shareholder and stakeholder engagement. Empowered stakeholder mechanisms such as advisory panels or stakeholder boards are needed. Stronger regulatory oversight to assess and enforce directors' compliance with stakeholder considerations are also needed. Ultimately, aligning directors' duties with stakeholder interests is not just a legal or moral imperative, it is essential for long-term corporate resilience and sustainability. Thank you for listening.